I'm Daniel Abramoff with the Counsel House Podcast. Today, my guest is Chuck Webb, lead antitrust counsel at FedEx. With over 25 years of legal experience, Chuck began his career with major law firms where he spent 11 years practicing. He then transitioned in-house to Walmart, focusing on ethics and compliance in antitrust before joining FedEx 5 years ago. For today's discussion, we'll delve into the role of AI in antitrust regulatory challenges, the intersections of ESG, and the complexities of international antitrust regulations and enforcement. Chuck, thanks so much for joining us.
Thank you, Daniel. It's my pleasure.
In June 2023, the European Antitrust Horizontal Guidelines included new guidance on evaluating sustainability agreements among competitors. These guidelines made it clear that ESG initiatives cannot be used to greenwash cartels or inherently anti-competitive conduct. However, they also provide a framework for assessing agreements genuinely aimed at promoting sustainability objectives under EU competition law and establish a safe harbor for sustainability standards that meet specific criteria. Can you share your insights on the evolving landscape of antitrust regulations in the context of ESG initiatives? Specifically, how much cooperation among competitors is permissible to achieve common ESG goals, and particularly considering the European authorities' position?
Well, thank you, Daniel. And this is obviously a very relevant question for FedEx. We have a overall corporate goal of achieving carbon neutrality by 2040. And that's no small task given our corporate footprint. That includes having over 215,000 motorized vehicles worldwide, everything from delivery vans to big 18-wheeler semi-trucks. We operate over 700 aircraft worldwide, from small Cessna planes to large 777s that are flying right now over the Pacific and the Atlantic. We operate 5,000 facilities worldwide, again, from office buildings to huge hubs at airports. We employ over 500,000 people globally, and we deliver 15 million packages per day. And also, our footprint is global, and I appreciate the international context of your question. We operate in over 220 countries and territories worldwide. So concerning specifically ESG, as you said, in June 2023, the European Union, or specifically DG Comp, put out relatively clear guidance on how you can construct agreements among competitors to comply, to reach your legitimate ESG goals and could still comply with European competition law. They make clear, by the way, that you can't use ESG to quote unquote greenwash a cartel or otherwise patently anti-competitive agreements among competitors. But again, they provide that kind of relatively clear guidance on kind of the rules of the road on how you can reach legitimate sustainability objectives within the context of competition law. Now, contrast that to the United States, where it's fair to say in the US on kind of both the federal and the state level, where we can both enforce antitrust law, both federal and state enforcers are taking to put it frankly, a more conservative or cautious approach. Now, back in 2019, at the federal level, you had Assistant Attorney General for the DOJ Antitrust Division, Malcolm Delrahim. He warned that agreements among competitors on how they should act in the marketplace with respect to ESG goals may draw scrutiny under the U.S. antitrust laws. And then in February 2019, under the Trump administration, they actually opened an investigation into an agreement that 4 major auto manufacturers had with the state of California on to achieve stricter emission standards, potentially how that could violate U.S. antitrust laws. Now, that investigation was closed in February 2020 with no action. Under the Biden administration, neither the FTC nor DOJ have taken enforcement action solely based on ESG, although you did have in September 2022, both FTC Chair Lina Khan and Assistant Attorney General for the DOJ Antitrust Division, Jonathan Kanter, in congressional testimony confirmed that there is no ESG exception to the U.S. federal antitrust laws. So no enforcement action in the federal section under the Biden administration, but also no assurance or no guidance on how you can construct agreements in compliance with antitrust laws. Now, that's the federal level. On the state level, state antitrust laws, you have had some at least investigations related to ESG. In March 2022, the Arizona Attorney General announced the opening of an investigation into a group called Climate Action 100 Plus, which is an investor-led coalition focused on climate change. And that investigation, as announced by the Arizona AG, centered on whether the institutional investors are using the coalition to compel companies to agree to reduce or eliminate new investment in oil and gas exploration. That investigation subsequently in 2022 expanded to include 19 Republican-led state attorney generals, where they sent a letter to the CEO of BlackRock expressing concern that coordinated action among financial institutions through organizations such as Climate Action 100 Plus could violate Section 1 of the Sherman Act. Subsequently, in December 2022, a group of House Republicans sent a letter to the Climate Action 100 Plus Steering Committee requesting information about ESG-related activities and expressing concern that those activities could violate the U.S. antitrust laws. In response, in February 2024, JP Morgan, State Street, and BlackRock stated their public intention to either withdraw from or not renew their memberships in Climate Action 100 Plus. So, Daniel, we're seeing kind of a clear divergence, in my opinion, of approaches to antitrust related to ESG and enforcers in the US and Europe. And frankly, that divergence was on display for the entire antitrust community and frankly, the public on April 12, 2024, at the conclusion of the ABA Antitrust Spring Meeting, which is the largest gathering of antitrust attorneys annually globally. There on the same stage, you had the head of competition for Europe, Vice President Margaret Vestager. She actually very passionately explained, it was quite touching. She said how she recently saw the birth of her first granddaughter, and she joked that she now knows somebody who will be alive in the 22nd century. And then she turned and said, well, it's up to us to determine what kind of world that generation will inherit. And now is the critical time to take action to combat climate change. She put that as the background context of the EC guidelines that you mentioned at the start of this question. On the same stage, you had Assistant Attorney General Cantor and FTC Chair Khan reaffirmed that there's no ESG exception to the U.S. antitrust laws, and neither would agree to a proposal for a workshop between the U.S. and the EU to help find common ground on this subject. So we clearly have an area of divergence here. It's not as you said, I've been in this business for a while. I've seen other areas of divergence between the U.S. And the European Union on competition law or antitrust policy. But I'd say unlike prior areas of divergence, this one is not based on kind of theories of antitrust or different views of economics. This one, unfortunately, is just based on kind of the difference in politics I think we're seeing more broadly on climate change between the U.S. and Europe.
That is so fascinating. And I appreciate you kind of dropping the different pieces, the highlights of what has been going on in this space. And it's certainly in my mind, and I think in others listening, it is highlighting the fact that we're still, the antitrust law has been around for a very long time, but with these new industries, these new regulatory challenges that come up, it does create a almost somewhat of a separation between folks who initially were coming into the room with the same type of mentality. But I appreciate you kind of explaining the situation. I think that, I'm hopeful that it's a matter of time until everyone can come to that table and create that workshop, that much needed workshop, because what you're saying is obviously there's two sides to this coin, and you want to try to meet in the middle as best as possible for the future of everyone. In two recent statements of interest jointly filed by the FTC and DOJ in private civil matters, the agencies made clear that the price fixing through AI is still price fixing. As AI becomes increasingly prevalent in various industries, including antitrust, what are your thoughts on its role and potential implications in antitrust enforcement? And could you elaborate on the differences between legal conduct and price fixing scenarios in the context of AI-driven pricing decisions?
Sure, Daniel. These are two interesting cases, and they both involve so one was involving landlords and rental rates, and the other was involving hotel prices, specifically for casino hotel rooms. The core action there was that the different competitors, whether they be landlords or hotel operators, were using the same provider of algorithmic pricing software, which looks at market data and then generates suggested prices in local markets. And the concern expressed broadly by the DOJ and FTC was that the use of that common software allowed the landlords on the one hand or the hotel operators on the other to collude on prices. Now, the agencies made three basic arguments in their submissions. The first is you don't need direct communication between competitors to have a price fixing agreement. So the concern expressed by the agencies was that it's the use of this common software provider allowed the landlords on the one hand, the hotels on the other, to collude on pricing. And the agencies expressed three fundamental concerns. The first was you don't need direct communication between the competitors to have a price fixing agreement, particularly when all the competitors in both of these markets have chosen to use a common algorithmic software provider. Concern number two is that the setting of the initial or base price can still violate antitrust laws, even when that's not the ultimate price consumers are going to pay. And the third point made by the agency was that agreeing to use a common pricing algorithm can still be unlawful when the individual companies retain some pricing discretion. The use of pricing algorithms is kind of a frontier issue and a frontier AI issue, as you suggest. But the 3 points the agencies lay out, I would argue, are very traditional antitrust doctrine, going back many, many years. There was a case in the 1940s decided by the Supreme Court called the Saccone vacuum case, which held that any agreement among competitors that tampers with their pricing structure is unlawful under the Sherman Act. And I would argue, even though this is in the new context of kind of pricing algorithm software, I think it kind of solidly follows under that long line of precedent under Saccone vacuum, which says that an agreement among competitors which affects their pricing structure is going to be held illegal under the competition laws.
Chuck, I do have a fun hypothetical scenario
Sure.
then to give you. So we have two retailers, retailer A and retailer B. Both are utilizing AI and web scraping to collect and analyze each other's pricing data to make pricing decisions. Do you believe that this would cross any legal boundaries regarding collusion or agreement?
Well, this is an interesting hypo, and this actually goes beyond the pricing algorithm cases we were just talking. So, Daniel, I mean, there's always, you use the retailer A and retailer B hypo. Let me actually go a step back on that, and let me do the gas station hypo. And I used to teach antitrust law, and this is what you learn day one of law school in antitrust class. Let's say you have two gasoline stations in a town, and they both publicly display their prices. Let's say gas station A publicly displays a gallon of gas is $2.20 a gallon. And the owner of gas station B walks by and says, I see gas station A is charging $2.20 per gallon of gasoline. I think I'll charge that too. Traditionally in antitrust law, going back over 100 years, that has not been illegal. Simply observing your competitors' prices, public prices in the marketplace, and having that being a factor in your own pricing decisions is not a violation of the antitrust laws. Where the line has been drawn is, let's say, instead of just observing the prices, you have gas station owner B calling gas station owner A and saying, hey, I see you're charging $2.20 today. What are you charging next week? And that's been the line. You need some sort of communication in addition to common market conduct to show what the Supreme Court has said is a conscious commitment to a common scheme to have an antitrust violation. Now, Let's put that simple hypothetical into the very complex world of AI. Let's say, instead of having two gas stations, you have two different retailers, or it's three or four different retailers, but they're all using AI-driven technology or software programs to scrape volumes of pricing data off each other's websites multiple times a day. And off that data, they're making real-time pricing adjustments, sometimes just, let's say, based on AI-driven pricing adjustments based on the information they're scraping. And let's say the AI programs themselves are then evolving, machine learning, and adjusting their prices and adjusting their processes based on the trends they're seeing in the markets. And you have multiple competitors AI processes doing this simultaneously. At that point, where is the line between acting unilaterally, observing publicly available information, or reaching some sort of common understanding? And is human intervention even needed in that process? And that's what makes it different from the algorithm cases in the rental area and the hotel rooms that we just discussed. There, you still had human beings in the different competitors saying, yes, I'm going to use the same algorithmic software provider as my competitors. But in this second scenario, if you simply have computers scraping prices and making pricing decisions, do you need human intervention somewhere for an antitrust violation? In my view, I still think you need a human intervention at some point, but that's my view. Others may have a different view, that you can get a meeting of the minds solely through the use of computers and technology. I don't know the answer to that question, Daniel, but it's something that'll be played out in probably the years to come, especially as technology advances and changes.
Chuck, with antitrust enforcement becoming more globalized, what challenges and opportunities do you foresee in navigating international antitrust regulations and enforcement actions? And how does the approach to antitrust compliance vary across jurisdictions?
Well, Daniel, as I mentioned, we were talking about ESG. FedEx, we operate in 220 countries and territories globally. At the same time, today, over 120 countries and territories enforce some form of antitrust or competition law. So this global approach, and how do you construct a compliance program globally, is very important to us. Now, antitrust compliance, which I'm responsible for, it's part of our global compliance program, which is part of our culture of compliance. And that culture of compliance at FedEx is in turn part of our broader corporate culture of the company. Now, if I can, let me just read for a second the first paragraph of the FedEx Global Antitrust and Competition Law Compliance Policy, which, by the way, is available online. If you Google FedEx Antitrust Policy, this will pop up. So if you look at that, page 1, paragraph 1 states the following, I quote, FedEx thrives in competitive markets, and actions that violate antitrust and competition laws, such as agreements among competitors to fix prices or divide markets, are prohibited and simply not the way FedEx does business. Now, that language is in there intentionally, Daniel. It just says that there are certain core principles for our antitrust compliance program that apply globally, notwithstanding whether antitrust law is even in effect or the variances in antitrust law or competition laws. So, for example, regardless of jurisdiction, we are not going to enter into anti-competitive agreements with our competitors. That is a global fundamental principle. Now, antitrust law, of course, can be complex. There are other areas, what I was just talking about are agreements among competitors. There are other areas of antitrust law, such as rules covering vertical price fixing. So let's say instead of agreements among competitors, you have a supplier and customer. That in the vertical context, the rules of antitrust or competition may vary, they actually do vary substantially among jurisdictions. And in those kind of situations, I don't want to have a global standard that may make my company uncompetitive or hinder our ability to serve customers in ways that may be permitted under specific antitrust or competition laws. And those standards may vary by country or jurisdiction. So these kind of decisions, they need to be made knowingly, but not haphazardly. And again, the 120 countries that now enforce some form of competition law, most of those, or many or most of those, have come online within the past 25 years, so within this century. And a global company like FedEx, you can't just assume the way you've done business in the past 25 years is the way you can continue to do business for the next 25 years, because standards, including antitrust or competition standards, may have changed. So that's why while certain principles such as we won't agree with our competitors on prices, customers, et cetera, that's immutable, that's core around the world. In other more complex areas, you may have variance in kind of your business practices based on specifics of local law. But those variances, they need to be made knowingly based on how the laws are today. And you can't just assume the way you've been doing business is the way you can continue to do business. The culture of compliance at FedEx is part of our global corporate culture, including our compliance culture. And I have to mention that Ethisphere has now recognized FedEx 2 years running as one of the world's most ethical companies based on our compliance program and based on our compliance culture. And we are the only honoree in the logistics industry.
Many jurisdictions, including the US and Europe, have leniency or immunity programs that incentivize companies to report cartels or other anti-competitive conduct that the agency may not already know about. And doing so could result in avoiding fines altogether for the first to report, or a reduction in fines for others to report, so long as they're cooperating in the ensuing investigation. Could you discuss the role of AI and data analytics in detecting and investigating cartels, especially considering the trend of leniency applications? And how do you see the utilization of data analytics impacting corporate compliance efforts?
Well, since another interesting question, let me pick up where you left off. You mentioned in your question the trends in leniency applications. I'd say we look at 10 years ago, leniency applications, when they first came online, 15 years ago now, they were very popular in the United States and Europe, and you had a high amount of leniency applications and resulting cartel cases. And why? It's because the incentives that they created. As you said, if you were first in the door, you can avoid fines. If you were second, third in the door, fourth in the door, et cetera, you can have a reduction in potential fines and penalties so long as you cooperated with the investigation. The trends we've seen in the past 2 years now is that both in the US and in Europe and in other jurisdictions, leniency applications are substantially down. Now, there's several debates about why that is. Potentially, there's just better compliance with companies. But there's also the burden. On the other hand, there's the burdens of cooperating with the investigation. There's expanded risks of private litigation. I really can't answer that question about why applications are down. But if you're an agency now, you kind of have a potential problem of, well, what are you going to do? And how do you detect cartels? When leniency was hot, you literally had most of your cases walking right through the front door with people bringing leniency and immunity applications. Now that's starting to dry up a bit. So what we've seen is competition agencies relying more on data analytics to potentially detect anti-competitive conduct and bring what's called ex officio investigations. Investigations they're starting kind of on their own without an otherwise leniency application or an informant. Let's say that's someone kind of giving them inside information. What factors are they looking at? Well, that's an interesting question. I think they're looking at factors such as price changes, the timing of price increases. On the other hand, in addition to kind of looking more at market data factors and using AI to look at more data analytics, agencies have also publicly announced that they are greatly expanding their resources dedicated to market surveillance, and they're hiring more data analytics specialists. And we're starting to see in certain jurisdictions the bringing of the first ex officio investigations, cartel investigations, based on data analytics alone. Again, not based on a leniency application or not based on a whistleblower. This will be an increasing trend in what we see globally from enforcement authorities. And it creates kind of an interesting, I wouldn't say problem, but just kind of something that as someone in compliance like myself will need to address going forward. At the same time, agencies like the United States, like Canada, have produced guidelines on what constitutes an effective compliance program for antitrust. They are very, very useful guidelines. One of the pieces of guidance is you need to proactively monitor or have surveillance for anti-competitive conduct. Well, the problem or the potential problem or complexity you have for monitoring is also the potential complexity you have for data analytics on the agency side. Is you just have, companies are making pricing decisions every day. You have vast amount of pricing decisions. As I said in response earlier, traditionally simply observing what's going out there in the market, what information, the prices your competitors have out there publicly in the marketplace, and using that as a factor to make your own pricing decisions has not been subject to antitrust violations. So from a compliance standpoint, I think both from a compliance standpoint for monitoring and also an agency standpoint for surveillance, it's a very difficult question is given the vast amounts of data, which are getting vaster and vaster as we go forward, how do you separate, how do you find that needle in the haystack representative of price fixing versus just this is representative of fair competition on the merits? And that's, I think, a difficult issue both for companies and both for agencies.
It will be very interesting to see the types of responses that come out in the future from the government in terms of how they want everyone to be able to safeguard their data and preserve just in case. It's very fascinating.
Sure.
Given your background as a law firm partner, government enforcer, and a law professor, how do you perceive the role of academia in shaping antitrust policies and practices? And how can academic research contribute to a deeper understanding of complex antitrust issues?
I have been in the antitrust profession now for 25 years, and I've kind of seen it from all sides. I will say this definitively. In my career, there has been no other time as dynamic in terms of both how markets are changing and how antitrust law is potentially changing to police those markets as we see now. And frankly, also, there is no more exciting time to be an antitrust professional, whether you be a lawyer or economist or otherwise, than right now. This is a great time to be in this profession, and it's a great time to get into this profession. We've seen this change in the past 25 years. The way markets are developing with stuff like AI, I don't think this dynamism or this rate of change is going to stop or slow down anytime in the next 25 years. So it's, again, great time to be an antitrust lawyer. I think all sides of our profession, whether it be the agencies, law firms, academia, industry, organizations such as the American Bar Association, I think we all have important roles to play in helping shape how antitrust, this body of law and policy that originated in the late 19th century, how it's going to evolve and will continue to evolve to be an effective policing of markets and ensure the benefits of competition throughout the 21st century and even looking into the 22nd century, which frankly is not that far away. So I think all areas of antitrust are going to have an important role to play to contribute to that debate. And frankly, Daniel, I think even thinking more broadly, I think your podcast, Counsel House, and other similar channels also have an important role to play in highlighting the importance of this debate to the broader audience. Let me take a step back and get personal for a second. In 1972, the late great Justice Thurgood Marshall said that, quote, the antitrust laws are the Magna Carta of free enterprise, and that they, again, quote, they are as important to the preservation of our economic freedoms as the Bill of Rights are to the protection of our personal freedoms. Now, it is that sort of notion expressed by Justice Marshall that was part of the reason that I initially became an antitrust lawyer in the first place. And it still frankly motivates me to get out of bed and tackle the antitrust challenges I will see on a day-to-day basis. Now, given the vital importance of antitrust to our free enterprise system, it's important that everyone in the antitrust community contributes to that debate about where this doctrine of law and policy is going. But it's also vitally important that the broader society and community be informed about the antitrust debate and know where it's going and have the opportunity to contribute to it. So that's why channels such as Counsel House are so important to inform the broader audience of that debate and give them a chance to contribute to it.
I appreciate that so much. And that was initially and still is and will always be the goal for this podcast, to be able to get experts like yourself away from the craziness that's flying around and sit down and discuss exactly your thoughts on what has happened and what's going on and what will be the future. Antitrust sounds incredibly fascinating moving into the future with all these bubbles blowing up into other more and more bubbles. We need the right professionals. We need those attorneys to come in here and be able to build that community around how they feel antitrust should be perceived and initiated moving forward. So I'm really grateful to have you as our guest. I mean, I think this was an excellent interview, and for those who are listening, I hope you all have benefited immensely.
And thank you, Daniel. It's been a pleasure for me, and I just appreciate the opportunity.